A father of two was gunned down, shot and killed in the middle of a karaoke performance at an Ohio bar. Witnesses say Benjamin Hawk had just started singing when out of nowhere, shots rang out. Police say the suspected gunman, 59-year-old Richard Lindgren, walked up behind Hawk and opened fire. And jealousy may have been the motive, as Hawk was reportedly singing with Lindgren's ex-wife. I'm Kennedi Walker, and you're watching Law and Crime.
And if the sun comes up tomorrow, let her be.
It started as a normal night at a local bar in Buckeye Lake, Ohio. Karaoke, music, people just out having a good time. But that changed in an instant. 42-year-old Benjamin Hawk was shot and killed while performing karaoke, and now 59-year-old Richard Lindgren is behind bars accused of pulling the trigger. Lindgren walked into the bar just after 9:30 p.m. on Saturday, according to police. Moments later, Hawk was shot in the back of the head while on stage singing. Police have not confirmed the motive, but court documents reveal Hawk was singing with Lindgren's ex-wife at the time. Several people witnessed the shooting and called 911, but Lindgren was already gone. That's when a multi-state manhunt began. A nationwide warrant was issued, labeling Lindgren armed and dangerous. The Licking County Sheriff's Office shared a photo of Lindgren's vehicle and reached out to law enforcement across South Carolina, Georgia, and Florida after Lindgren's car was picked up by two flock license plate cameras in South Carolina. That digital trail led to his arrest in Orangeburg, South Carolina, where a state trooper and deputies stopped his vehicle and took him into custody. Back in Ohio, the focus is on Benjamin Hawk, the man whose life was cut short. He loved singing and was the 2025 Karaoke Cup state finalist. He leaves behind two daughters. In a statement, his family wrote that Hawk was loved by many and never met a stranger. He had the ability to converse with any and everyone. They went on to say he always looked out for those around him and would give his very last to someone in need, even if it meant he had to go without. Now his family has to find a way to live without him. And here to break down this story with me is attorney and retired judge Fanon Rucker. Fanon, thank you so much for coming on today.
Thank you so much for having me.
So let's just jump right in. I know you have seen countless violent crime cases, but this one, mid-song in front of a crowd, how does the law approach something that public and personal?
Well, first of all, when we talk about the extreme nature of this individual's conduct, and we're talking about murder or the death of another person, in Ohio, there's kind of four different ways to look at it. There's aggravated murder, with saying you're in the commission of another offense, or it was a police officer or something like that. Murder, voluntary manslaughter, involuntary manslaughter, negligent homicide. I think this falls squarely within the parameters of murder. Murder is the killing of with malice of forethought, where somebody said, I'm going to take this person's life. There was some planning and design, no matter how long it lasted. And I think that that's what applies here. But that's how the law will look at it. But I think a jury or a judge are going to look at this with extreme eyes, just like the rest of the public when they hear it.
This is a Law and Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease? And research is potentially linking ultra-processed foods to these outcomes. Morgan & Morgan is stepping in to fight to hold food companies accountable. With decades of experience fighting large corporations, they're ready to stand up for families who deserve justice. If your child who's under 21 has been diagnosed with type 2 diabetes or fatty liver disease, visit www.forthepeople.com/food or scan the QR code on your screen to learn more. Absolutely. And when we're talking about murder, how many years is he facing? I'm assuming life, but in Ohio, you guys have the death penalty. Is this a death penalty case we're potentially looking at?
Well, in order for him to be facing the death penalty, that would have to be aggravated murder. And in order for aggravated murder to apply, it would have to be, again, during the commission of a felony. So say he was in the process of kidnapping this individual and he shot him as a result, or perhaps he did it for hire, or it turns out that this person was actually a law enforcement officer that he knew was a law enforcement officer acting undercover. Then under those circumstances, there could be some argument that the death penalty specification should be applied. I don't know that what I'm hearing here justifies them seeking the death penalty for this crime.
But if it is just murder, no death penalty, he's looking at spending the rest of his life behind bars, correct?
He would be looking at life. That is correct. Life would be the maximum penalty that he could face.
Right. Does the fact that the suspect fled just immediately add legal weight, or does that just support an existing charge like murder?
Well, when we look at charges and the proof of offenses, people's conduct before and many times after is what the courts or the prosecutors use to explain that this was something that they did intentionally, and that that their actions after the fact proved they were trying to cover up for, which means they knew that they were wrong in what they did, not that he hung around and did something which perhaps showed that mentally he wasn't there. No, he was present of mind to commit this act and then try to hide his conduct or evade capture by taking off. It's not an element of the offense, but most certainly it is a fact that the prosecutors will hammer home that this individual needs punishment for what he did because of his attempt to evade arrest afterwards.
Right. And it seems like you see some premeditation here. I mean, it seems as if you could argue that. What do you think, just in your opinion?
That's right. It's clear that this person knew or expected that and what we know is, again, that the individual who was shot was the boyfriend of the woman's excuse me, his girlfriend was the ex-wife of the guy who shot him. And so what do we know right now? We know that he shot him and they were together at the time. We don't know how long he had been following him. The investigation will meet that out. We don't know what other communications there had been, if there had been warnings of him to stay away, or if he threatened this guy to her at other times. We don't know those facts yet, but all of those would add in more evidence of the prior motive and the calculation and the design that this person had to actually ultimately engage in this conduct on that particular day. I do want to make the distinction. In law school, we talked about what essentially in Ohio would be involuntary manslaughter. And that would be a circumstance where somebody, and the example we used to give in law school is where someone came home and their spouse was in bed with the mailman. No offense to any mail carriers out there. But that would, the response that a person would give by taking someone's life in that instance would not justify murder. It would be involuntary or voluntary manslaughter, meaning I was caught up in the heat of passion when I saw this act involving my spouse, and I lost my mind, and that's what I did. It would require then a lesser consequence. I don't think that's what we have here, because he went on stage, stood behind him, and shot him while they were singing. I don't know that anyone can argue that if you're in a public place singing karaoke, that would inflame the passions so much that it would require you to take someone's life.
Right. And plus, just on top of that, like how you said, this is the woman that was singing with the victim was the suspect's ex-wife. So no type of situation like you're walking in on your spouse or anything like that in this case. Just very mind-boggling when you think about the fact that it was done in public. But just digging into just the layers of relationship and intent, it, like how we said, it kind of seems like there's some type of motive here. And how might prosecutors use that in court? I know you said like we still have to do some digging. I'm assuming they may be going through the suspect's cell phone, maybe even the woman's cell phone. Just how do prosecutors begin making this case?
Sure. There are some cases that, and we laud and applaud the police officers and the investigators and the detectives for, a crime being committed, and then them having to kind of recreate the scenes and recreate the instances in order to figure out who done it. Here, we didn't need to do that. This was, as you said, in public. This was in front of a crowd. I'm suspecting if it was karaoke, that there were plenty of cell phones out recording, and so it was known pretty quickly who was the perpetrator. And so once you immediately remove the threat by issuing an arrest warrant and arresting that person and putting them behind bars so that they can't commit any other similar acts while the case is pending, now the investigators, prosecutors, police officers go about the business of getting search warrants to search this person's home, getting search warrants to go through their cell phone, talking to witnesses, neighbors, friends, family members, to get any other supporting information to further solidify their case. I mean, they got a pretty solid case, it sounds like, just in the fact that this incident happened. But what if the defense is that this person was suffering from some mental defect or some mental disease and didn't understand or appreciate the nature of what he was doing in the time that he did it? So the investigations that will be conducted by the prosecutor and by the detectives going forward will be to collect all of those additional pieces of evidence to close the door on those potential defenses that we believe the defense may ultimately raise in a case like this.
Right, because I mean, maybe can we expect that the defense is going to try to argue some type of temporary insanity or extreme emotional distress in this case? Would it hold up? Because, like you said, it's not like the situation where a husband is walking in on his wife. This is very different circumstances, correct?
Yeah. So every case is is given to its particulars and to its facts. So are there circumstances that would justify the argument that he was not in his right mind? Well, I mean, maybe he just got the divorce papers that day, like 5 minutes before. Maybe, a minute before his ex-wife sent him a video of some salacious video of him and a young child. I mean, who knows? But that is absolutely a potential argument that the defense could raise, depending on what facts or circumstances present themselves during the investigation. What I see and what we see right now, based on what happened, I think it'd be a pretty hard argument to make that this was temporary insanity. And again, I'm guessing that as the investigation comes out, there's going to be some proof that he followed them, knew where they were going to be, kind of laid in wait, waited until this guy got on stage. I mean, arguably he could have done this at any other time, caught him in the parking lot when he first saw him or something. But he laid in wait until this individual was on the stage with his wife singing a song, and that's when he walked up behind him and shot him. I mean, it's outrageous, number one, that it's done, but the idea of the brazen nature of it in public in front of other people is it's pretty scary.
Right. And is it just a clear case of just the definition between a crime of passion and premeditated murder? Like we're seeing the difference right now, correct?
That's right. Crime of passion, again, is something that happened in that particular moment. I mean, I hate to be crass or insensitive, but maybe he's going to argue that the particular song that they were singing was their song, or it was their wedding song, and that so inflamed his passion in that moment. Yeah, but he had a gun in the club, in the first place, where he believed, or where they ended up performing karaoke. So I think it's a difficult argument for them to make. But outside of something like that, in the heat of the passion, is really just that. It's in the moment. It was so unexpected, and I just couldn't grab control of my mental faculties, and I just lost all control, and I took someone's life. I think that the circumstances of this murder make that a very, very difficult argument to make.
Correct. And of course, we're waiting on more details to come out. But according to social media, it seemed like this venue where they were singing karaoke is a place where the victim frequented. So I'm sure that will probably make the argument of maybe he just, came in and didn't even know that he was going to see them. I'm sure that probably won't work. But like how you said, every case is different. Now, the suspect did flee, according to police. How significant is it that he crossed state lines? Does that change the charges or jurisdiction?
No, it's not uncommon when people. Well, I say it's not uncommon. We've heard plenty of instances where people will commit serious crimes, and to avoid being prosecuted or avoid being caught, they'll skip over state lines and go change their appearance, assume different names, and hide out in other states. It does not change the nature of the offense. Now, if in the process of fleeing, he grabbed his ex-wife and took her across state lines, well, now you potentially do have federal charges for taking people across state lines to commit criminal acts, which would be the kidnapping. I mean, but something like that. But just the fact of him going to another state, he was found 5 states away or 4 states away in South Carolina, I believe. That the fact that they found him there would not necessarily add extra charges to the most serious charge that he's already facing right now.
Can you break down how a nationwide warrant works and what makes someone armed and dangerous legally?
Well, so law enforcement agencies, there's something called the NCIC, the National Crime Investigative Computer, I believe is what it's called, but it's the database, the national database that law enforcement agencies have access to, where they're able to put in an individual's name, their age, date of birth, gender, height, identifying scars, marks, tattoos, and the information about whatever it is that they're charged with or wanted for. And as part of that information they're putting in, they also can identify whether or not the person is wanted for a violent offense, so that it gives a notification when that person's name is run or their social security is run when they are actually discovered. And we live in a technology age. When I first started as a prosecutor, back when there was still a 19 in front of our years, we had computers and fax machines, but there wasn't as free flow of information and as much communication between all agencies as there is now. I mean, we have facial recognition software right now. We have fingerprint technology in most jails, where that fingerprint will then go into a national database, which will immediately identify if that person has been arrested or is being held in any other jail across the country. I mean, the level of connectedness that we have now has made, I suspect, apprehending criminals a lot more efficient than it used to be when old prosecutors like myself were calling up people in small towns, asking them if they have anybody new in town that they are not familiar with, to see if they fit these descriptions. So that is an additional piece that assists significantly in interdiction of crimes.
Absolutely. And technology really was helpful in this case. I mean, authorities using flock cameras to pick up the suspect's car, according to documents. I mean, just that technology, the fact that they were able to help track suspects today. I mean, sometimes when you think about these criminals, I know there's no such thing as a smart criminal, but if you could just touch on the fact of, like, it's not as easy as people think to just, oh, I'm going to commit this crime and then run away. Like, somehow, some way, with all the technology that we have today in 2025, and it's only getting better, it seems, you're going to get caught.
Yeah, there were movies, in the 90s and in the 80s that kind of showed, 30 years from now or 30 years from then, that we would be able to, go to a football game and they would immediately, see us and know us. That actually exists now. You think of movies like Enemy of the State, where certain words that are spoken, triggers certain information or certain technology that begins the recording process. Well, I don't know that we're there, but everywhere we go, almost anywhere, we're being filmed. There's films on the tops of street lights that law enforcement agencies have put up in different cities. Police officers have on their cars license plate readers, and of course, most of us have camera phones and Ring cameras on our houses, and so it's a lot easier now to track the movement of individuals once you start at a specific point, and you can kind of pinpoint their movements and their locations by anticipating where they went, and eliminate places where they didn't go by going back through those cameras. And of course, eyes in the sky are also extremely helpful. Again, our privacy is only as effective as us turning off all cameras and computers in our homes, turning off cell phones, and not going outside, because literally there are eyes all over the place through technology that are monitoring our movements, making evading from arrest extremely difficult in 2025 and beyond.
Right. It's kind of scary if you think about it. The way you were breaking down everything made me a little nervous, but very, very true. And also, something that I find just, I don't know if shocking is the right word, is that when people are in one state, they may commit a crime and then they go, like in this case, a few states over. It's still the United States. You're going to get extradited back to where, you committed this alleged crime. So if you could just explain how seamless the extradition process is, especially state to state.
Yeah. And we've seen some high profile cases over the past few years where individuals were extradited back to the states where the crimes were committed. When a person commits a crime, for instance, in Ohio, But even, and we were right across the river from Kentucky, but if a person is Kentucky, they can't simply drive them over across the line. Either the person has to do something called waiving extradition, meaning, hey, you have these charges over across in that other state. Are you willing to consent to us transporting you back to that particular state? Or they have to go through the legal process, which would require the originating state where the warrant is issued and who's looking to prosecute them has to provide documentation, certified, notarized, and everything to the agency or to the state that actually is holding the person. There has to be a court hearing, because due process is extremely important, where the judge or the magistrate hears the evidence or reviews the evidence that has been provided from the state where the warrant is, and then signs off on it. Normally that takes somewhere between 10 and 30 days for that process if the person does not waive extradition. If you waive it, then it's a much faster process to begin, facing the charges that one has pending against them. I mean, it's a process, and anytime there's a process, it has to be believed that you can object to it, and that ultimately it can be denied. Like they can say, no, I'm not waiving extradition, and the court process can ultimately determine that they're not in a proper legal position to be extradited. But I am certainly not aware, in almost 30 years of practice, of a time when extradition was denied by court process.
Yeah, well, looking ahead, just how soon do you think we'll see this case go to trial, and what happens in the meantime?
Well, the general time frame for serious felonies and murder charges is usually about 1.5 to 2 years. There is a significant time that the courts allow for the collection and review of evidence, which includes for the defense and the prosecutors to speak to witness, send out detectives and investigators to file motions. I mean, there's always all types of motions that are filed, from motions to suppress evidence that may be being sought to be admitted at trial, like a gun or something else, or there may be pretrial motions to eliminate certain photographs because the jury may be inflamed if they see it. I mean, there's all types of processes in place. And so usually between the time that a person first appears in front of a court to the time of trial, it can be 1.5 to 2 years. Now, we had a case here a couple of years ago where a person was sitting in jail, innocent of a crime, because you're innocent until proven guilty, on a murder charge, I believe for 7 years before their trial was actually moved forward. And that's, all kind of delays may occur that make that happen. But on average, about 1.5 to 2 years.
Wow. Well, before I let you go, I mean, you just touched a little bit on the jury. Do you think just the emotional weight of the victim's death, being a father, he was in the middle of singing karaoke, I mean, just all of that will shape the tone of this trial, if it does go to trial, because this could end up in a plea, correct?
That's right. I mean, obviously, we do know that the greatest majority of cases that are filed in court end up in pleas. That's just the nature of our court system, and so it's possible that this may end up in a plea as well. But if it does go to a jury, I mean, those are everyday regular citizens who have raised their hands and sworn through a questioning process to, without bias, without prejudice, without passion, listen to the evidence, listen to the law, and make a decision. We presume that when jurors take that oath and take on that difficult obligation, that's exactly what they'll do. That's difficult. That's incredibly difficult because, like I said, they're just everyday citizens. And they do see themselves in that father. They do see themselves in that wife or that ex-wife. They do see themselves as a person in the audience who was present when this outrageous act occurred. And it is a lot of times difficult for jurors to put aside those personal feelings to make an unbiased and unprejudiced decision. But again, we expect that they do when they swear to do that, and that's what we'll expect that they will be able to do at the appropriate time. But it's not easy. And I've talked to many jurors after my trials, and they've talked about the difficulty that they experienced when they were executing their duties.
Absolutely. Well, this is a case that we will be following closely. Fanon, thank you so much for coming on today.
Thank you so much for having me.
Deputies are beginning the extradition process to bring Lindgren back to Licking County. Benjamin Honk's family has made a GoFundMe page, and they are asking for donations to pay for his burial. For Law and Crime, I'm Kennedi Walker.